the defense is not saying that Dr. Pritchard was just disclosed as a witness. The state keeps saying, well, he's been on the witness list since January, so this is not a discovery violation. That's not the issue. The issue is that we were just told that there is a new expert opinion. And if I may approach, I would provide the court and counsel the case of Scipio, S-C-I-P-I-O v. State. It's found at 928 Southern 2nd, 1138, 2006. This case is analogous to this situation because it's a witness who had been listed, the defense knew about it, it's the medical examiner's office, investigator, they knew about it. There was no surprise that this witness was on the witness list and he was going to testify. The difference is that this witness had a change of opinion during trial, and that caused obviously a discovery violation such that the case was remanded. That is the situation that we are in with Dr. Pritchard. Yes, we know he's been a witness, but the difference is in the middle of trial, after the jury is sworn, the state is now saying, and we have this whole other area that he is going to give an opinion. And it's not a different opinion than what his mental health mitigation is, like would be directly on Scipio. This is, and we have this whole new area that he's going to talk about. I'm not going to take issue with the state's comment that they're entitled to use an expert to prove cold, calculated, and premeditated. If they had disclosed that expert testimony before trial started, not wait until the middle of trial when decisions have been made on our experts and putting us in a position where we have no ability to rebut or properly cross-examine this witness. We will not be able to cross-examine this witness on this opinion without infecting the mental health mitigation presentation. We will most likely, we'll have to figure it out if the court allows this, figure it out, but we are unable to see how we can possibly cross-examine this witness on this issue without going into the material that was developed through the evaluation. Nowhere through the evaluation, through the deposition, through any discussions about this witness has it ever been brought to the defense's attention that the state intended to use this witness to provide expert opinion to prove cold, calculated, and premeditated. This witness has only been listed and did an evaluation and deposed on the issue of rebuttal of the state's mental health mitigation. We would ask that his testimony be prohibited. Go ahead, that's a new idea.
The deposition of Dr. Pritchard says an individual is typically able to describe their hallucinations, maybe not when they're active. Sometimes they're just too disorganized and too distracted, too distressed. Hallucinations, real hallucinations, most of them are very tormenting to an individual. It disrupts their life. People would notice if a person's really touching a hallucination. It would be really unusual. So the expectation would be that people would notice that. We would see that. Clinicians would see that. Lay people would see that. That's the way we know a person is having hallucinations. You can tell that they're really distracted by their misperception. They think it's real. But typically they can't because they're interacting with it or they're distracted. You see them being distracted. Or sometimes it's a funny hallucination. They'll laugh when they shouldn't laugh. I mean, it's pretty clear in this deposition that the defense knew and knows what Dr. Pritchard was going to say. And when you compare it to the case Scipio that was just provided to the court, the state's purposeful failure to advise the defense of material change in deposition testimony of a medical examiner's investigator was found harmful. There is no material change from what the defense deposition of Dr. Pritchard revealed when they took his deposition than what we're talking about putting on in the state's case in chief. It is entirely distinguishable from what the defense is saying.
The defense is asking for a Richardson hearing. Richardson is invoked when there is a claim of a newly discovered evidence, newly discovered witness, and it's basically an improper timing issue, and the determination has to be made by the court whether or not a violation has been made, whether or not it's inadvertent or willful, trivial or substantial, and what effect there has been on the opposing side, in this case the defendant, to properly prepare for trial. The court determines, based on arguments of counsel, that there is a distinction with regard to what this witness is expected to testify in the state's case in chief versus what they would be using this witness to do with regard to any rebuttal should defense place the mental health mitigation issues before the jury at the conclusion of the state's case in chief. I believe I understood, if I'm incorrect in that determination, Mr. Johnson, please correct me, but that's what I thought I heard your explanation is. There's basically two pieces to what this expert intends to show with regard to your testimony, asking him questions, and without regard to any evaluation, his opinion regards Mr. Xavier's interrogation and his evaluation of that interrogation as it relates to cold, calculated, premeditated, versus rebuttal after the evaluation that was taken of Mr. Xavier at a later time, the interviewing and the evaluation. Am I correct?
Yes, Judge. Nothing the state would go anywhere near rebuttal testimony of Dr. Macklis or whoever, the witnesses, the state's witnesses, expert witnesses rebutting. This is simply the factual observations that Dr. Pritchard made of the bank video, the 911 call, and that material that is so wholly independent from information gathered from Mr. Xavier.
I'm not sure that there has been any sort of violation. If there were to be determined a violation by the appellate court, however, that for some reason the state was intending to call this witness in its case in chief regarding the factual determination of their burden regarding whole, calculated, and premeditated versus the rebuttal, I would find that the violation was not willful. And in fact, it would have been inadvertent, because there's a distinction between a fact witness or an opinion witness during the case in chief versus rebuttal opinion after there has been a determination by defense if they choose to put on their mitigation. The content of the opinion has not changed from what the state is indicating, but there's not a change in opinion, so there is, I'm not finding that there's a violation, but if there were one, it would be inadvertent. It may or may not be substantial, but the effect is that if there is something that defense doesn't believe that they've heard with regard to the rebuttal side of it, there's time for defense to cure that issue with regard to taking an additional supplemental deposition of this witness at some point during the presentation. And of course the state is instructed to not present any rebuttal, but to present only what it has indicated to the court would be presented during the case in chief, and that is the evaluation of the statements made by Mr. Xavier during law enforcement's interrogation in January of 2019 as it relates to the opinion of the expert regarding the hallucinations. So you are permitted to do that during your case in chief, and for that the motion to strike is denied. With that caveat that if you all need to or believe you need to take an additional deposition, the court would not prevent that from happening at all. What else do we need to take care of before we address jury stuff? Defense, anything else?
Nothing from the defense.
State, are there any matters to take up?
Nothing to station.
It was brought to the court's attention this morning by the bailiffs that one of our jurors, juror 768, Daniel Payne, is out of state with a spouse emergency surgery. And I have directed that that juror provide information to the court from the hospital that that person needs to be part of the court record. We do have 13 people present, and we will need to proceed without juror 768 present, since that person is not here. I present that information to you. Any response?
No response.
Defense, any response?
We maintain all of our previous objections, motions to the prospective, or to the jurors that were sworn. We do not accept the panel, we do not accept the jurors. We maintain all of our objections.
And your objections are noted, the previous rulings apply. And before we bring in our jurors and the court reads the preliminary instructions, it has been a few minutes. Does anyone need a moment for a comfort break to go off the record for just a few moments, like maybe 3 or 4 minutes before we reconvene, gather our thoughts, bring in our jurors, and let you all begin your opening statements?
Same will defer to the defense.
We do not request it.
You're good? Everyone's good? Okay. Then if we can verify our jurors are all in good shape, we will bring them in. And while we're doing that, just so you know, we do have blank notepads and fresh pens. I will read the note-taking instruction so that the jurors may take notes during the trial if they choose to do so. I can pause it. Let's be in recess while our jurors get themselves gathered together. Thank you.
charge up over here.
Do what? Oh, okay. Right. Oh. Well, see, y'all made it up here.
We did.
Okay, so I gave decent direction. Good job. So, no problem. I didn't catch you. Our first witness is in that. Yeah, that's 7:4.
Okay, perfect. But just so you know, that's where she is. Scoot. The receiver.
disconnect and to obey the court's order under pain of contempt of court if they fail to obey the court's order, that no witnesses are intended to be in here or watch the live stream. Otherwise, I don't think there are any witnesses in here, and the state, since you have the first week, you are directing, correct, Mr. Johnson, your witnesses not to have any contact with anyone except y'all and not to speak amongst themselves. I presume you are taking care of directing that court order.
Yes, Judge. As far as we're aware, the witnesses have been made aware that they're not to discuss anything amongst each other. Now, some people are family members, so testimony things. The remaining are law enforcement, and of course, they're fully familiar with the rules. And then the out-of-state people, I believe, the court has addressed that insofar as having published that order. So my understanding is we have that covered. If the state has any knowledge that there is any issue with that, we will of course bring it to the court's attention and the defendant's attention.
Thank you. Anything else? May we please bring in our jurors? Thank you. Good morning.
Good morning.
I have a couple of things to put on the record before we begin. First, the court has invoked the rule of sequestration of witnesses. If any witnesses are attempting to observe the live stream, you must disconnect. You are not permitted to watch the live stream, as the rule of sequestration of witnesses indicates that no one may watch or observe anything going on during the trial unless you are on the witness stand, under pain of contempt of court should such happen. Now,
Good morning, members of the jury.
Good morning.
The first question I always ask you once we've separated and gotten back together is this. Has anyone attempted to approach you or speak with you, or have you learned anything about this case between the time we separated on Friday afternoon and got back together this morning?
No.
Anyone at all raise your hand? There are no hands raised. Now, members of the jury, I'm going to read to you some instructions. I would much prefer, of course, to talk with you. However, I'm required to read to you very specific words, and so I'm going to have to look down, but I will attempt to look up occasionally. Members of the jury, the defendant has pled and been found guilty of 5 counts of first-degree murder in a previous proceeding. The only issue before you is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it'll be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits may be produced as evidence. This evidence is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. Aggravating factors. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: 1. Zephan Allen Xaver was previously or contemporaneously convicted of another capital felony. The crime of first-degree murder is a capital felony. 2. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Marisol Lopez, Deborah Cook, Anna Maria Williams, Jessica Montague, and or Cynthia Watson. 3. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means The murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Once the state has presented evidence of the existence of an aggravating factor, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Mitigating circumstances. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released. You will then begin your deliberations. You should not form any definite or fixed opinion until you have heard all of the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss the case amongst yourselves. Your decision must be based solely on the evidence or the lack of evidence in the law. During the penalty phase, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury, ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to any bailiff, who will then advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is off. At the end of the case, while you're deliberating, you mustn't communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices, and that includes electronic watches. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay, and a contact phone number can be provided so that someone could contact the court if you are expecting some sort of emergency. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or to the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people or places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about the case face to face, you mustn't talk about the case using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for all of these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information that you obtain is proper for this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you might find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present arguments with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary. If it becomes necessary that one of those conferences may take a little longer than expected, we'll very likely simply ask you to retire to your jury deliberation room. I call it your home away from home, so that you can be comfortable, use the restroom or such as that, while we take care of matters outside your presence. Now, if you would like to take notes during this event, you may do so. On the other hand, you're not required to do so if you don't choose to do so. That's left up to you individually. However, you will be provided with a notepad and pen by the bailiff for you to take notes if you wish to do so. Any notes that you take are for your personal use. However, you should not take them with you from the courtroom. What I'm going to encourage you to do is when you get your notepad and pen, write your juror number on the front of it, and then flip the page to begin taking any notes. Keep it flipped closed and flipped upside down in your chair. While this trial is going on, there will be signs posted on the outside of the doors that when we're not in here, no one is to enter, no one is to clean, no one touches anything in this courtroom while this case is ongoing. So you can freely leave your notepads in your chair when you go to lunch, when we go for a break, when you go home for the evening. Those notes will not be taken with you until you actually go back to deliberate your decision. Now, during recesses, you will leave your notes in the chair, and after you have completed your deliberations, which is when you take your notes with you, the bailiff will gather up your notepads and deliver them directly to me, no one else. They are not read, they will be destroyed. I will tear off all the pages that have writing on them, plus a few extras if there are. I do not read what's written. I simply clear out the notepad for reuse if there's enough pages. If not, I will destroy the entire notepad. I take those notes upstairs to the large shredder, and I personally shred all of your notes. No one reads your notes. They are not part of the court record. They're for your use if you choose to do so. However, do not get so involved in your note-taking that you become distracted from the proceedings. Your notes should only be used as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence. You should not be unduly influenced by other jurors' notes. You might have just jotted down a thought or two, and someone else may have page after page in a second notepad. Do not abandon your memory of what you perceived the evidence to be just because someone else wrote different notes. That's for their business, it's not yours. Notes are not entitled to any greater weight than each juror's memory of the evidence. If the bailiff would not mind delivering some notepads and pens. When you get them, please make sure that your pens work. If you need an additional pen or if you need an additional pad, simply hold it up and we'll get a new one to you momentarily. Determined whether or not you need a new pen or your pen's working. It should be brand new. Very good. State, do you wish to make an opening statement?
Yes, thank you. Good morning.
Good morning.
You've heard through jury selection why you are here. You've now heard the preliminary instructions that the court has given you. And now the parties have an opportunity to make what's called an opening statement. And I'm going to begin by reminding you that the state has the burden of proving aggravating factors in this case. And what those aggravating factors are reasons, if proven, why the death penalty is appropriate in this case. Now, before I get started going through what I believe the evidence will show in this case, I want to introduce you to a few folks. Marisol Lopez, Deborah Cook, Anna Williams, Jessica Montague, and Cynthia Watson. They may be referred to as victims. You may hear the word deceased, the word autopsy, bodies at a crime scene. And you're going to hear a lot about what happened to them, and how they died. But I think it's important to remember they're people. They were mothers, wives, daughters. The defendant, in this case, grew up in Plymouth, Indiana. It's a small Midwestern town about 40 miles south of South Bend, Indiana. And he lived most all of his life in that area. But then in May of 2018, he moved to Sebring. He moved in with his mother, Misty, and her then boyfriend, Ephraim McKelvey, into a small home at 311 Pine Tree Lane. Now, Misty and her boyfriend had moved to Florida a little before Zephan moved down to be with them. And he lived with his mother and her boyfriend through the summer, the fall. And around the end of November, the beginning of December, he got a job working as a correction officer trainee at the Avon Park Correctional Facility. And he later told police that he moved to Florida to get a fresh start. The evidence will show, or that was Pine Tree Lane, approximately. The evidence will show that on Wednesday, January 23rd, 2019, at approximately 12:32:36, we're talking about surveillance video for me to get those times, the defendant walked into the SunTrust Bank located at 1901 US 727 South in Sebring. He had armed himself with a 9mm Springfield handgun and was wearing a tactical vest that he had purchased about a week before. He waited in his car outside in the parking lot, and he waited until a male customer left, got into his car and backed out, and then the defendant walked into the bank. And he walked down from the southern entrance doors down to where the row of tellers is occupied. And he walked up to the bank counter where Marisol Lopez was stationed as a teller. Marisol had been a bank employee for 30 years. At 12:32:59, the defendant pulled that 9mm handgun from the pocket of the hoodie he was wearing, and he pointed it at Marisol Lopez. And he motioned for her to walk back around the teller counter. And at the same time, Marisol Lopez's neighbor and co-worker, Deborah Cook, was made to leave from behind the teller counters. They walked into the lobby area with their hands up, obviously not knowing what was going to happen to them. And as they entered the lobby area, that is right next to one of those bank employee desks where you sit down and you talk about paperwork, can I get a loan, I need to talk to somebody. And that station was occupied at that time by Anna Williams and Jessica Montague, who were helping a bank customer, Cynthia Watson, who had showed up over the lunch hour to do some banking. All 5 women standing in the lobby with their hands up, waiting. He then instructed Marisol Lopez to walk to the front door of the bank and lock it, and then go to the side door where he entered and lock that, ensuring that nobody could walk into the bank. Upon returning from locking the doors, Marisol joined the others with her hands up. And then the defendant ordered all 5 of them to pat, make sure they had nothing on them, and ordered them to lay on the floor, face down. Marisol Lopez, Deborah Cook, Anna Williams, Jessica Montague, and Cynthia Watson. And at 12:35:10, approximately 2 minutes after walking to the bank, the defendant began the execution of these 5 women. He started left to right. The first person that he shot was Marisol Lopez. Shot her in the back of the head as she laid there. And you will see that when that shot went off, the others flinched with that bang of that firearm inside of that space. Marisol Lopez was the first to get shot. Cynthia Watson picked up her head and looked in the direction of the defendant. He went out of order and turned and shot at her twice, hitting her in the head and in the arm. He then turned back to go systematically in order. He shot where he left off, shooting Deborah Cook in the back of the head. He then moved to the next victim, Anna Williams, shot her in the back of the head. And then finally, Jessica Montague, 31 years old, was shot in the back of the head. At 12:35:53, the defendant walked away from the women, reached into his pocket, and took out his cell phone and dialed 911. Told the operator, Kristen Johnson, that he had just shot 5 people. At 12:36:24, while still on the phone with 911, the defendant walked back over to where the 5 women lay and shot Cynthia Watson in the head again. And while on 911 call with Ms. Johnson, then went over and stood over Marisol Lopez and shot her in the head a second time. Approximately 4 minutes later, while still on the phone with 911, an elderly couple pulled up to the bank, Victor and Dina Sparks. And they walked up to the same door that the defendant entered the bank and began to tug on the doors, which were locked. And you will see the defendant, as he's on the phone, turn his arm over and wave off the 2 people. He told the operator, the 911 operator, when they asked, "Are they all dead?" He said, "I think one of the son of a bitches is still breathing." When he heard and saw law enforcement on their way, he squatted down and put his handgun to his head and continued talking with 911. At one point, he walked back into one of the bank offices, out of the sight of the surveillance cameras. Kristen Johnson, the original 911 operator, turned the call over to a crisis negotiator, Deputy Carr. He remained on the phone with the defendant for approximately an hour and a half. At 1:57, about an hour and a half after the murders, the Highlands County Sheriff's Office rammed the glass front doors of the bank with an armored riot control vehicle in order that the SWAT team could gain entrance into the bank. They had no idea what they would find. At 2 p.m., the SWAT team members began to enter the bank, secured the premises. About a half an hour later, the defendant emerged from the back room with his hands up and was taken into custody. You are sitting in a courtroom with a 5-time convicted murderer. As you heard in jury selection, there is no defense to these killings. There is no self-defense. There is no insanity. There is no heat of passion. There is no defensive accident. The state must prove to you in this case, in order for you to recommend the death penalty, at least one aggravating factor. At least one. Now, there are 3, but the state must prove at least one aggravating factor. The first one the judge just read to you. Zephyr Allen Xavier was previously or contemporaneously convicted of another capital felony. The crime of first-degree murder is a capital felony. 5 convictions. By that plea, the defendant has admitted to that aggravating factor. Aggravating factor number 2. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. It is the kind of crime intended to be included as especially heinous, atrocious, or cruel as one accompanied by additional acts that show the crime was consciousnessless, pitiless, and was unnecessarily torturous to Marisol Lopez, Deborah Cook, Anna Williams, Jessica Montague, and Cynthia Watson. The evidence will show as they laid there, as they were systematically shot, they had to wait to die. Unnecessarily torturous. They were not shot instantly. They flinched. They knew the doors were locked. They were made to show they were defenseless. They were made to lay on the floor and systematically shot, one at a time. Consciencelessness, pitiless, and unnecessarily torturous to each victim as they waited. You will see evidence of the defendant's motive in this case as to what perhaps was going through his mind at that moment. A note from his phone that was extracted by law enforcement that was dated January 10th, 2019, 13 days before the murders. My heart races as I crave the taste of blood and mayhem. I thrive on chaos. It makes me feel whole. Without it, my chest pains as I try to fit in a puzzle I don't belong. I can't help what I love, and I love seeing the death and destruction. Wonder what it'd be like to truly kill. Aggravating factor number 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix an exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant, and it must be formed before the killing, after a substantial period of reflection. I want to talk about what the evidence will show with regard to that substantial reflection. Because it doesn't just begin that morning, and we'll talk about that. And it doesn't just begin a week or two before that. It goes back years. On January 7th, now this is a couple weeks before the murders, the defendant entered the SunTrust Bank where the murders occurred, and he deposited his check from the corrections department from working as a trainee. He then went to the tax collector and got a new driver's license. On January 8th, the following day, at 2:59, he went back to the SunTrust Bank and he took out $300 from the ATM, cash. Now remember I said that was at 2:59, bank surveillance time. And at 3:05, approximately 3:05, the defendant entered Boom Boom's, which at the time was a gun store on South 27, and he purchased a handgun, the one used in these murders. But the gun cost more than $300 in cash, so he paid with a credit card. And you will see that on the video from Boom Boom's gun store. He goes to the kiosk and fills out the ATF paperwork that asks a lot of questions. And he answers each question, never revealing some information about his past. A day later, January 9th, he goes into Avon Park Correctional and he resigns. He then joins an online group, which is found in his cell phone download, called Suicide Isn't the Solution. On January 10th, he authors the note that I just read to you about what it would truly be like to kill. On January 12th, several days later, he enters Boom Boom's again, but this time it's to pick up the 9mm handgun that he's purchased. Of course, you know, if you don't have a concealed weapons permit, well, I guess at this point, unless you don't have that, you can't buy a gun. It can't be transferred for 3 days. So the 3 days goes by. He walks into the store moments after it opens. He then texts his younger brother, Zachary, we see this from his phone, pictures of his new gun. Now, his brother still lives up in Indiana. And he shares the happiness with his brother that he's able to purchase a handgun. And they talk about laser sights. You got to get a red dot. Brother talks about wanting to get a gun himself. January 16th, several days before the homicide, the defendant joins an online chat group called Murderous Thoughts. On January 18th, 5 days before the murders, he joins a chat group, Murder and Stuff. The chat room that discusses serial murders and cases. He asks the chat room, so do you know what happens to the family of a killer if the killer is killed while the police are trying to capture him or her? Are they fined, punished, or just meh, M-E-H? I don't know, IDK is the response. To which the defendant responds with, I can never find the answer, no matter where I look. On January 22nd, at 10:56 p.m., the defendant sends a text on his phone to a deceased friend that has died back in December of 2016, one of his best friends. And in part it reads, I know I'll see you in hell tomorrow, and I know you won't like me for everything I've done. I miss you, asshole, and I'm beating your ass when I get to hell. On January 23rd at 7:42, the defendant reaches out to an old online girlfriend that he has had since before 2016, 3 years or so before. Her name is Imani Davis, and she was an online girlfriend. They discussed everything with each other. They had as much of an intimate relationship on a cell phone or electronic devices as you can have. They shared their thoughts, their dreams, and you will hear from Imani. And she was a little surprised that he had texted her that morning, because she hadn't heard from him in about 6 months. They had had a fight back in May of 2018, kind of right after he moved down here, and they hadn't communicated. But at 7:42 a.m. on the morning of the homicide, he reaches out to her. Now, they met many years ago on a website called Spells of Magic, where they discuss all kinds of stuff related to witchcraft and, death and things like that. So they've had this on and off relationship. She's surprised that he reaches out, and he tells her at 8:34 a.m., this is about 4 hours before the murders, that it is the best day of his life, and that he will explain why in a bit. At around 8:55 a.m., he texts her and says, I'm laying in bed thinking. At 9:03, he says, I'm thinking about horrible things, and I'll tell you around noon or so in 3 hours. That's what he says. That's at 9:03. At 9:04, he searches the internet. SunTrust. They continue to text on this Google Hangout app for the next couple of hours. And at 11:53, the defendant texts Imani, I'm getting dressed and brushing my teeth, and then I will tell you why I'm excited and having a damn good day. 12:04, he texts her, I am here and done and ready. 12:14 p.m., he texts her, I am dying today. Yep, today is the day. Now, they continue to text. Imani is in Connecticut, and she's in high school. And she's responding to texts in between classes, or when she can sneak her phone away to go, what are you talking about? And you will hear from her. And you will hear from her the almost incredulity that what are you talking about? And at 12:30 and 55 seconds, the defendant texts her, but the fun part, right? The, quote, fucking cliche clincher is that I'm not going out alone. I am taking a few people with me because I've always wanted to kill people. So I'm going to try it and see how it goes. Watch me on the news in Sebring, Florida. 1 minute later, he got out of his car and walked into the bank. So we have the morning of as cold, calculated, and premeditated. We have the weeks before
purchasing the gun, the vest that he walks into with a metal plate, the text to his deceased friend, the poem that he writes on January 10th. But this desire or this plan to kill goes back much, much further than even that. In fact, it goes back years. Imani Davis, his longtime on and off girlfriend, will tell you that when they first met on this Spells of Magic, she was interested in serial killers and all the gory stuff, watching gory movies, the lives of serial killers, blood and guts movies. But she'll tell you there was a difference between her interest and the defendant's interest. He was more interested in doing it, not just reading about it, researching it. He had told her before they had met, he had gotten in trouble in school a couple years before for talking about a dream that he had to the school nurse, saying, I had a dream that I want to barricade the door and kill the people in my class. And he was upset that he got in trouble for that at the time. Imani and him continued to talk about this fascination with killing up and until Mr. Xavier had to say a bit of an online goodbye to her because he was joining the United States Army. And he applied, and he was sent to boot camp in a place called Fort Leonard Wood, Missouri. He talked about how he was excited to go in the military, and then told Imani that he had planned on bringing back skulls as souvenirs so that he could eat and drink out of them. She'll say she thought that was a little creepy, but it was consistent with this mantra and discussion about wanting to be involved with death. Once he got to boot camp, he met a fellow soldier-to-be named Erica Chevalot at basic training. They became friends, and she will testify that he seemed to embrace making people feel uncomfortable. And at one point, he gave her a note that said, I'm feeling homicidal. I want to kill. She had a discussion with him and said, you really need to go tell somebody like the sergeant about this. And he did. And he was discharged from the Army in June of 2016 after having gone through several months of boot camp. And he went home. About a year later, his co-soldier-to-be had completed boot camp and become a reservist in the United States Army in Michigan, where she lived. And she decided one day, about a year later, to reach out to the defendant, just to see how he was, what he was up to. He was out of the Army, what he up to. And so she looked him up on social media and found him. And there they rekindled a friendship online, but she had known him in person. And she'll testify that it turned dark, expressing a desire, for example, to enter a bank and to kill people. This is in or around March and April of 2017. In their Facebook discussions, there is a quote, partial quote by the defendant to Erica. I love the idea of murdering people. At that point, their relationship became kind of strained as she was uncomfortable enough that she went to the Michigan State Police and said, hey, I've been talking online to a friend of mine, and this is what the threat is. Michigan State Police then contacted the local police in Indiana, who followed up and checked on the status of Mr. Xavier in Indiana. Nothing, however, was done. A year later, the defendant moved to Florida from Plymouth. And that was in May of 2018. So from school, telling the nurse I had a dream about killing people, to Amani Davis, the girlfriend, 2016 and before, wanting to kill or hurt people, to that wanting to kill people when in the military, to a year out of the military, love the idea of murdering people. And then to Sebring for a fresh, new start. Sebring offered a fresh start, a new home away from Plymouth with his mom, a chance to be away from Plymouth, Indiana, and his father, whom you will hear Amani talk about the difficult relationship he and his father had, the strict disciplinarian, and the defendant not wanting to follow those rules. So here we are away from Plymouth, Indiana in Sebring. A new job at the Department of Corrections, arguably, according to his text, making more money than he's ever made. Co-workers at the jail, the prison, that extend friendship, invite him to parties. Car of his own to travel where he wanted to, although he had to reimburse his mom monthly for the car expense. Travel where he wants. We'll see records of activities, going to restaurants, Dairy Queen, McDonald's, every restaurant you can imagine here and around the Sebring area. But what did the defendant do with the fresh start that he was given? He let those thoughts of murder, death, those desires to kill, to destroy innocent lives in the community that welcomed him. Ladies and gentlemen, the evidence in this case, the state believes will prove to you beyond a reasonable doubt that the defendant in this case deserves the state's most severe punishment for his actions. And at the end of the evidence, after you've heard all the evidence, the very end that we talked about, the state will come up here at this podium and ask you to recommend the death sentence in this case. Thank you.
State calls Kristen Johnson.
You are about to give is the truth, the whole truth, and nothing but the truth to help you God.
Come right this way now.
Good morning.
Good morning.
Can you please state your name and spell your first and last name for the record?
My name is Kristen Johnson, K-R-I-S-T-I-N, Johnson, J-O-H-N-S-O-N.
Ms. Johnson, where did you work back in January of 2019?
At the Highlands County Sheriff's Office
What capacity did you work at the sheriff's office in?
as a telecommunicator.
And for those who are not not familiar with what telecommunicator means, what are the basic duties of a telecommunicator?
Answer 911 calls and admin line calls.
And on January 23rd of 2019, how long had you been a telecommunicator for the sheriff's office?
About 8 months.
I want to direct your attention to that date. Were you working that day?
Yes.
Now, while working as a telecommunicator, did you receive and participate in a 911 call at approximately 12:30 p.m.?
Yes.
And that call would have been received around 12:36?
Yes.
What was the phone number that was recorded as having placed the call?
I don't recall.
Is there a document where that is recorded that would assist in refreshing your recollection?
A CAD document.
Okay. And for the record, I'm going to show you receiver and call history, page 1 of 8. You may review that and let me know if that refreshes your memory.
Yes.
What was the phone number that was recorded by the system as having placed the call?
574-301-9842.
Now, did the caller identify where they were calling from?
Yes.
Where were they calling from?
The SunTrust Bank.
Now, did the caller ever identify themselves to you?
No.
Now, when a call comes into 911, are those calls recorded?
Yes.
And are they stored in a manner that allows them to later be downloaded and replayed?
Yes.
And the call that you participated in, was that call recorded?
Yes.
For the record, I'm showing the defense counsel states exhibit 218. I am showing you states exhibit number 218. Do you recognize this document or that disc?
Yes.
And at an earlier time, did you have an opportunity to listen to the contents of that disc?
Yes.
And were you able to verify that that is a true and accurate recording of the 911 call that you participated in on January 23rd of 2019?
Yes.
Your Honor, State would move states 218 in the evidence at this time.
No objection. It will be received as State's Exhibit 218 in evidence.
Your Honor, at this time the State would publish.
You may do so.
Yes, I'm at the SunTrust in Sebring.
All right, SunTrust Bank in Sebring.
Yes.
What's the address there?
I have no idea.
Is it going to be 1901 US 27 South?
Hey,
Yes. And what's going on there? Sir, what's going on? Sir, what's going on at the SunTrust Bank in Sebring?
I just killed 5 people. Well, technically about to be 6.
Can you repeat that?
I killed 5.
You just killed 5 people?
Yes. I honestly didn't think I could do it. But
Why did you do that?
I honestly don't know.
Sir, what did you kill them with?
9mm.
A 9mm?
Yep.
Where are they?
Lying up against the wall, like I told you to.
They're lying up against the wall like you told them to?
Yep.
Okay. Why did you do this?
I don't know. I thought that I could. I wanted to do everything, but
You wanted to do it?
yes, I really are.
Do you know them?
But
Do you know those people? Where is your gun right now?
In my hand.
What are you wearing? And where are you?
In the lobby, wearing a gray sweatshirt. I'm getting ready to kill myself too.
You're getting ready to kill yourself too? Why are you going to do this, sir?
Because I thought it was a little thing.
Why?
Yeah.
Can you please explain it to me?
I don't know.
You don't know why you're going to do it?
I wanted to die since I was 9. I wanted to quit since I was 11.
Why?
So,
What is your name?
not important. You can find it on my body.
What is your name?
You can find it on my body.
I'm sorry, I can't understand you. Can you say your name again?
You can find it on my body.
It's on your bike? Where is your bike?
My body.
Your body? Why is that? Why are they going to be able to find it on your body?
Because I won't be allowed to tell them again.
Can you put the gun down?
No, I cannot.
We have people coming to help you. Can you put the gun down?
There's no help.
But why is there no help? What's going on? We've got people going to help you, okay? What happened?
You don't understand, but she's still breathing regularly. You hurry, you might get to it. If not,
She's still breathing?
regularly, someday might hear in the wall.
Okay.
But
When did you do this?
just now,
Just
and
now.
this is it. I can see the top going up, so I'm,
Okay, can you stay on the line with me? Can you please stay on the line with me, sir. What is your name?
you can find it on my body.
Please, sir, can you stay on the line with me? We're gonna get you help.
I don't want help.
Can you please stay on the line with me? We're gonna get you help. What happened to you that you wanted to kill yourself since you were 9?
Something broke. Nothing fixed it.
What broke?
I don't know.
What happened when you were 9 years old?
I don't know.
You're not sure what happened? Were you living here in Sebring?
No, it was not.
Where were you living?
No, no.
Where were you living? We want to help you. I really want to help you.
But you don't understand, I don't want help.
I really want to help you, sir. I really want to help you. And I don't want anything to happen, okay? Why did you go to the SunTrust Bank today?
So I could do that.
So you could do that, but why did you choose the SunTrust Bank?
I don't know.
You're not sure? Okay. Do you have any other weapons on you or just the one?
I've got a knife in my pocket.
You have a knife in your pocket too?
Yeah.
Okay. You have a knife in your pocket too. Is it going to stay in your pocket?
Probably.
Okay.
Hold it in my head like that.
Please, sir, I really want to help you. Can you please stay on the line with me? We're going to get you help. Can you please stay on the line with me? Are you still in the lobby?
Yes, I am.
You're still in the lobby? Is there anyone else in the lobby with you?
There's the 5 horses.
Just the 5 people that you killed?
Yes.
Okay. We're going to try to get you some help, okay? Why did you want to kill people today?
I felt like doing it.
You just felt like doing it?
I've been getting told to kill people since I was probably 11 years old.
Who has been telling you to kill people since you were 11?
Myself. Down the voices. My
Okay.
fucking head.
Where is the gun right now?
Up against my head.
Please, sir, can you put the gun down?
No.
Okay. Can you please put the gun down, sir?
No.
Okay, I understand. I just really want to help. I really want to help you. So, since you were 11 years old, do you take any medications?
I haven't since I was 17.
Okay. Is anybody else still breathing now?
I don't hear the whine. It's getting very ragged.
It's getting really ragged. It's a male or a female that's still breathing.
Every last one of them's female.
Female. Okay. Please stay with me, sir, okay? Are they customers or do they work there?
All but one of them work here.
All but one of them work there? Do you have any family here in Sebring?
Yes, I do.
You have family here? Who is your family that's here in Sebring?
My mother.
Your mother lives here? What's your mother's name?
You find that out later.
Okay. Do you live with her?
You find that out later too.
Okay, I understand. Please stay on the line with me, okay? How long have you been here in Sebring?
You find that out later.
Okay, I understand. We really want to get you help, okay? And you just went into the SunTrust Bank today. Do you bank at SunTrust?
Yes, I do.
You bank at SunTrust? Okay. Have you been in there before?
Yes, I have.
Okay. Were you upset with somebody at SunTrust?
No.
Were you upset with anybody at the SunTrust?
No.
No. Okay. And you said you were riding your bike. Where's your bike?
I'm not on a bike.
You're not on a bike? Did you drive a car there or did you walk there?
Drove.
You drove a car there? What kind of car did you drive?
Get right off the front door. You can see it.
Okay. Okay, the car is outside the front door? Okay. All right. Okay. Please stay on the line with me, sir. Where's the gun right now?
In my hand, it's in my head. Maybe it was 5 minutes ago.
Okay, and you're still in the lobby?
Yep.
Okay. Where are you in the lobby? Are you by the tellers, or are you sitting in one of the chairs, or in one of the offices?
Not far from the bodies.
You're by the bodies?
Not far from them.
And where are they?
You look in the fucking main door, facing the highway. You all five of them laying on the wall.
Did you say anything to them?
You get up against the wall.
So they're up against the wall?
On their stomachs up against the wall.
Okay. What else did you say to them?
Got from behind the counter, go over there, and that's that.
Okay. Did you tell them why you wanted to kill them?
No.
You didn't say anything to them. Did they ask you any questions?
Why?
They asked you why. Did you tell them why?
No.
Okay. And then what did you do?
Nothing.
Okay. Was it very fast?
I tried to make it that way.
Okay, I understand. And then you called us right away?
Yes, I did.
Okay.
Just know what I'm doing is wrong. Can't get them to stop.
You can't get what to stop?
The voices.
The voices? What are the voices telling you?
You bring me to pull the fucking trigger.
Just stay on the line with me, okay? Were they telling you to do this all morning? Were the voices telling you to do this all morning?
And they started telling me to do exactly what I'm doing right now.
Okay.
About a week ago.
They started telling you to do this about a week ago.
Mm-hmm.
Okay. And they were telling you to do this every day? Every minute and every hour. Did you lock the doors?
I had them lock it, yeah.
Yeah, you had them lock it. Okay, are all the doors locked?
From what I know.
Okay. Okay. All right. Stay with me, okay? Stay with me, okay? So they were telling you this a week ago. Have the voices talked to you before and told you to do things like this before?
Since I was 11.
Since you were 11, okay. But you said something about when you were 9 years old. What happened when you were 9?
No.
You're not sure that's
Thank you.
okay?
I know what I do. Nothing fixes it.
So when you were 11 years old, where were you living? Were you living here in Florida or were you living somewhere else?
Tomorrow.
You were living somewhere else? Where were you living?
Tomorrow.
Okay. Was it up north or was it closer down south?
You find that out later.
Okay, I understand. I understand. Okay. Okay. How is the one person breathing? Is she still breathing?
Kind of sounds like she's choking on blood.
Okay.
I can go to the bathroom and we can go into the doors together.
Okay, you said that you can go into the bathroom and let them go into the doors to get her?
Absolutely. Bathroom.
The bathroom?
The back room.
The back room, okay. So you're willing to go into the back room and let them go in and get her? Let me let them know that, okay?
Two people I can still see breathing.
2 people are still breathing?
From what I can see.
Okay.
They're breathing.
Which ones are breathing? I know you said there was a female breathing. Who else is breathing? Is it another female or a male?
They're all females.
They're all females.
Separately.
Okay.
You're free to go in the door, but if it comes back,
Okay.
I don't know what we do about it.
Okay. Okay, so are you in the back room now?
Yeah.
You're in the back room.
Go facing the highway.
Okay, the room that you're in, the door is facing the highway?
No. The doors they can come in at, they can see them straight away. Facing the highway.
Did you unlock the door?
No. And I am not going to unlock the door. I don't know what I'll do.
Okay. Okay, so you're in a back room now, correct?
All the doors are shut.
Okay, all the doors are shut. And so how many back rooms are there? And which one are you in?
Don't know when they walk back here.
Okay, you don't know? Okay. Okay. Just stay with me, okay? So you're in one of the rooms. And there's nobody in there with you?
No.
Okay. Where is the gun now?
It's right here.
Okay. Can you put it down for me?
No.
Okay. Alright. Did you lock the door of the room that you're in, or is it unlocked? Can you say that again? I can't hear you.
No.
You don't know? Okay. Are you sitting down now, or are you still standing up?
Sitting down.
You're sitting down? Okay. Okay, you're sitting down. Alright. Are you sitting on one of the chairs, or are you sitting on the floor? Okay. Okay. Alright, so you're in one of the back rooms. The front door that they can get into is still locked, right? But they can come in. You're not going to come out? Okay. We're going to get you help. I really want to help you. I really want to help you, sir. I really want to help you. So why did the voices start telling you to do this last week? Do you know why they started telling you to do this?
Good.
You don't know why it started? Did something trigger it? Did something happen that you started having the voices tell you to do this?
I bought a gun. They kept talking. I quit my job because
You quit your job? Why did you quit your job? Can you tell me why you quit your job?
get funded by the inmates.
Can you say that again? I couldn't hear you clearly.
The voices told me to hurt the inmates.
Oh, the voices told you to hurt the inmates? The voices told you to hurt the inmates, so you quit your job?
Yeah.
Where did you work before?
The prison.
In a prison?
During the class break. Did you get students in the building thing?
Can you say that again? I couldn't hear you.
I haven't heard any glass break or doors open. I need to get those people.
I understand. We're working as fast as we can, okay? But we have to make sure everybody's safe, too. So you used to work in a prison. So you were helping people. So you quit last week? You quit last week. Did you quit because the voices told you to hurt the inmates last week? Oh, they were telling you to hurt people since you were 11. Have you heard anyone before?
Not like that.
Not like that. Okay. And today you just decided to do it? Were the voices getting louder and louder?
They finally shut up when I was finally doing it.
Yeah.
And now they're staring at me to do it.
Stay with me, okay? I really want to get you some help, okay? We got help on the way, okay? So you can just stay with me. Can you put the gun away? Can you put it away for me? Okay, I understand. For us to help you, I need you to put the gun away, okay? And I also want to help the other people that are still breathing. I understand that you want to help them too. I understand that. That's why you went into the back room. You saw they were still breathing and you wanted to get them help. But we need you to put the gun down and we need you to put it away so that we can get them help and we can help you. I really want to help you. And I understand the voices are really loud. I understand it. But I really want to help you. Did you talk to your mom today?
No.
You didn't talk to her today? No. Okay. How long has it been since you talked to your mom? Because she lives here, right? Did you see her today? You saw your mom today?
Yes.
Okay. And did you talk with your mom? Yeah, because your mom is your mom. She loves you, and she would want you to have help too. Moms are all the same. We love our children. And we don't want to see anything bad happen to our children. And we... Can you say that again? What happened for 8 years?
Don't anything for 8 years.
All right, sir. I have to ask you a question, okay? Are you comfortable talking with a negotiator? Would you be comfortable with that?
If the negotiator puts a bullet in my head, then sure.
No, we don't want to do that, sir. We want to help you. We want to help you, and I really want to help you, and I want to help the other people that are in there with you. Okay? We really want to help you. Would you please talk to a negotiator?
Do you have a gun?
I'm not sure. I really don't know.
If he does, something with the head.
Okay.
Maybe 5 guys too.
Can you say that again?
Yes, they maybe buy a vest along with the gun.
Bring a vest along with the gun? Bring a vest along with the gun?
No. If he transports Don't aim for the chest. They made me by them.
Do you have a vest on?
Yes.
Okay, so is it a bulletproof vest? Yes, it's a bulletproof vest? Okay. Okay. What's your mom's name? What do you call your mom? What's her first name? Can you say that again? It's nothing? I can't understand. I can't hear you clearly. Can you say it a little louder? I'm sorry. Can you say it louder? Okay. All right, so you have a vest on. Okay. Okay. Can you tell me what prison you worked at? Was it here? Did you work at a prison here locally, or was it one that was further away? It was here. Was it the one in Avon Park?
Yes.
Okay, so you worked at the prison at Avon Park. Okay. And you quit last week? Okay. Okay, I understand. I understand. So, how long were you working at the prison at Avon Park? Because that's really hard. That's really hard to work at a prison. So how long were you working there? You don't know how long you were working there? Was it a really long time? Because that's really hard. Okay. So you quit last week. And what have you been doing for this week? What were you doing? Because you didn't have to go to work, so what were you doing?
Trying to solve the problem before coming here.
Oh, you were trying to solve a problem? Do you have any children? Could they? No, you don't have any children? Okay. And you don't have a wife? Are you married? No, you're not married? Okay. So it's just your mom here? Okay. Alright, so it's just your mom here. Okay. Okay. Alright.
Did they get to them?
I'm not sure yet. I need you to put the gun down. I really need you to put it away so that they can help them. I know you want to help them. I know you do. And I really want to help them too. But I need you to put the gun away. I really need you to put the gun away. I really want my voice to be louder than those voices in your head. I really do, because I really want to help you. And I know that your mom wants you to have help too. I know she does. All moms do. They love their children, and I know she loves you. I know she does. And we never want to see anything happen to our babies. Okay. And for them to help the victims, we really need you to put the gun down. Because in order for them to come in, you've got to put the gun down, okay? We really want to help. We really want to help. You can't do it. You can't do it. Okay. Where's the gun right now?
Oh, yeah.
Okay, so, okay. 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 We really want to help. Okay. So, you quit your job last week and you've been trying to solve your problems. You told me you were trying to solve your problems this week. What problems were you having? Can you tell me? Can you say that again? I can't hear you. Can you say it again? What kind of problems were you having?
I'm the problem.
Oh, you're saying the problem was me? You mean it was you?
Yeah.
Okay. Was it the voices in your head? Was that the problem?
I just want you to stop.
Okay. So, can I have your name so I know what to call you? Can I have your name? No, you don't want to let me know. Okay. I understand. I understand. Okay, my name's Kristen. That's who you're talking to. Now that you know who I am, can I know who you are? No, you still don't want to tell me. Okay, that's okay. I understand. I understand. I understand. So you were trying to solve the problem this last week. So how were you trying to solve the problem? What were you doing? Did you go to the hospital last week after you quit? No. No, you didn't go to the hospital last week. Why didn't you go to the hospital? Okay. It worked when you were younger, or it didn't work when you were younger? Oh, it didn't work when you were younger, so that's why you didn't think it would be useful if you went to the hospital? How did they try to do it when you were younger? Did they give you any medications? What did they do when you were younger? Did they talk with you? I know it's really hard when you're a kid. I understand. I really do. Is it, did they give you medications?
Medication.
Yeah, they give you medication. Okay.
Nothing worked.
Nothing worked. Okay. How long did you take the medications for?
3 years.
So it never worked. Did you ever talk to anybody, or did they just give you the medications?
I talked to someone too.
Okay. Okay, that was a while ago. Did that help at all when you were talking to someone about it? No, it didn't help. How long were you talking to someone about it? Was it a while, or was it just a short time? No, it was a short time? Yeah. All right. I understand. I understand. So you're still in one of the back rooms? Okay. Is the door still closed? Yeah, the door is still closed. Did you lock the door, or is it unlocked? You're not sure? Okay. I wasn't sure if you would remember. That's okay. That's okay. So you have a vest on, and I know you have your gun. So can you put the gun down at least on the desk? At least on the desk. You don't have to put it away, but at least you can put it on the desk. Can you do that for me? So it's not in your hand? Can you do that for me? What? I can't understand you. Can you talk a little bit louder?
The only thing keeping them quiet.
I can only hear something about keeping quiet.
It keeps them quiet.
Oh, it keeps the voices quiet. Oh, I understand. Okay. So having the gun in your hand keeps the voices quiet?
No, it does my head.
Oh, having the gun to your head keeps the voices quiet. Okay. I understand. I understand. Okay. Alright. Okay. So you didn't talk to your mom today. Did you see her in the last week since you quit your job? You did? Okay. Did she say anything to you about quitting your job? No, she didn't say anything, yeah. She knew you quit your job, right? She didn't know? Oh, why didn't you tell your mom you quit your job? You just didn't want to. Can you say that again? I couldn't hear you. Okay.
I've written up the thing I don't before.
Okay. How was your job? Did you like your job? Did you like it? Did you like your job when you were working there? Because that's really hard. Sir, do you want to talk to your mom? No, you don't want to talk to your mom. Okay, I understand. I understand. Okay. Can you give us her name so that we can talk to her?
No.
Can I talk to her? No. Okay. I understand. I understand. Alright. So you didn't want us, you didn't tell your mom you quit your job, but did you like your job when you were doing it? Did you enjoy it? No. I think that would be a really hard job. That would be really stressful. I think it would be really stressful. Okay. Alright. Did you do it for a few years?
No.
Yeah, you did.
No.
Oh, you didn't? How long did you do it for? Can you tell me that? Oh, you don't know? Okay. 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 Because you have to go through a lot of training. It's hard. That's really hard work. It's really stressful. So I can understand. Did you have any other jobs while you were working there? Are you still with me? Okay, good. Thank you. Thank you. So do you live with your mom or do you live by yourself? Oh, you don't want to talk about it? It's okay. I understand. I understand. Sometimes it's hard. It's really hard. Okay. 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 Can you check on the victims for me? Okay, can you check on the victims for me?
I don't know what I'll do when I see them. I don't.
Oh, you don't know what you'll do when you see them. Okay, I understand.
I'm keeping them quiet. The gun in my head.
Okay, you're keeping the voices quiet with the gun to your head? Do you
I
want...
don't know what they'll do when they see them still alive. It's
I-
really hard.
I understand. Okay, would you be okay to speak to one of our deputies? I have Chris here, and he would like to talk with you. You're doing really good talking with me. Can you talk to Chris for me? Sure. Oh, thank you so much. Thank you so much, okay? That's wonderful, thank you. Okay. Thank you. Are you still sitting down? Okay. Are you still sitting down in the room? Yeah, you're still sitting down. Okay. Okay. Alright, we're gonna have Chris talk with you, okay? Okay, he should be here really soon. Okay.
Ms. Johnson, did that conclude your conversation with the 911 caller?
Yes.
All right. And at that point, did a deputy, Chris Carr, take over the conversation?
Yes.
Thank you. I turn it over.
Examination. No.
She may.
Thank you.
State calls Benjamin Silver.
Benjamin Schover.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Come right this way, sir.
Morning.
Morning.
Please state your name and spell your first and last name for the record.
Benjamin Schover, B-E-N-J-A-M-I-N, last name S-H-O-V-E-R.
How are you employed?
Truist Bank, investigator,
How long have you worked for Truist Bank?
12 years.
And back in January of 2019, was there a different entity that you worked for?
It was SunTrust at the time.
All right. And my understanding is SunTrust and BB&T merged to form Truist Bank?
That's correct.
What was your role for SunTrust Bank during the month of January of 2019?
Investigator.
What are the duties associated with that position?
We investigated workplace violence, branch robberies, property crimes, and persons crimes that were either on the property or involved employees or clients.
And what city and state did you physically work in?
Atlanta, Georgia.
Now, as an investigator for SunTrust, now Truist, do you have access to the surveillance cameras?
That's correct.
And are you able to view the cameras in real time?
Yes.
Are you also able to go back and look at historical footage?
Yes.
Do the cameras that are installed at SunTrust branches do they have the capacity to record video of events that are occurring within the branch?
Yes.
And in 2019, did SunTrust have branches located within the state of Florida?
Yes.
Was one of those branches located at 1901 U.S. Highway 27 South in Sebring, Florida?
Yes.
And was that known as the SunTrust Midtown branch?
Sebring Midtown, yes.
All right. Was that branch also equipped with video surveillance cameras?
Yes.
And were the cameras operable on January 23rd of 2019?
Yes.
How do you know?
We were able to successfully access the video cameras and view live and recorded footage.
Did the cameras that were equipped at that location have the ability to record?
Yes.
And how were the recordings stored?
They're stored on hard drives located on DVR that is at each branch location.
And who has access to those recordings?
Any employee with authorized access and authorization to access the video application.
And how long are the recordings stored for?
90 days.
And as far as the time and date stamp, how do you ensure accuracy at the time and date stamps?
The DVRs for each location are refreshed twice a day through the data center to ensure accuracy.
Now, how did you become aware of the incident that occurred at the Midtown branch on January 23rd?
The corporate security director advised that there was a report of an incident in and around the Sebring Midtown location.
And based on information received, what actions did you take?
We pulled up the surveillance cameras, the live footage at first to see if we could see anything going on inside the branch.
And as you pulled up the live footage, what were you able to observe?
Observed the 5 victims lying face down on the ground in the lobby of the branch, and the defendant was in the lobby as well.
And were you able to go back and review historical footage to determine what had happened?
That's correct, yes.
Now, after reviewing the video footage from the incident, were you able to get in contact with law enforcement?
I was.
And who did you speak with?
Contacted Sebring Police Department and was later put in contact with Detective Rittenhauer from Highlands County.
And were you able to assist the Highlands County Sheriff's Office in obtaining live video feeds so they could view what was going on within the branch?
We were, yes.
Now, eventually, did you assist the Sheriff's Office in obtaining video from the SunTrust?
That's correct. We allowed them to take the physical DVR from the branch location and they pulled video footage.
And that physical DVR, does that store the recordings of the events?
Correct. On the hard drives inside the DVR.
Now, as a investigator with SunTrust, were you able to access the same types of videos remotely from your location?
Correct, yes.
So are you familiar with the videos and the contents of the videos that were recorded on January 23rd of 2019?
Yes.
I'm showing defense states 222 and 223. I'm showing you states 222 and 223. Do you recognize these discs?
Yes.
And at an earlier time, did you have an opportunity to review the contents of these discs?
Yes.
And do the contents of these discs contain a fair and accurate copy of video recordings made by the camera system equipped at the SunTrust Midtown or the Sebring Midtown branch on January 23rd of 2019?
Yes.
And do they depict the incidents that occurred that day?
Yes.
Your Honor, State will move states 222 and 223 into evidence at this time.
No objection. They will be received as states exhibits 222 and 223 in evidence.
Now, as part of your investigation, did you come to learn the identity of the suspect?
Yes.
And were you able to determine that the suspect was in fact a SunTrust customer?
Yes.
And the suspect ended up being Zephon Xavier?
Yes.
Now, as an investigator, do you have access to the client account system?
Yes.
And what type of information does the client account system allow you to access?
We see their account profile, which has personal identification information, and also account history, transaction history.
And as a corporation, does SunTrust send out monthly statements to its customers?
Yes.
And do those customers contain records of transactions?
Yes.
And is that type of document one that is prepared and sent out during the ordinary course of SunTrust business?
Yes.
And are they made from records kept by the company?
Yes.
And is it a regular practice of the company to make and keep such records?
Yes.
And are they made by a person with knowledge?
Yes.
I'm showing defense counsel states 169. I'm showing you states 169. Do you recognize this exhibit?
Yes.
And how do you recognize it?
It appears to be a bank statement.
And is this a fair and accurate copy of bank statements for the customer, Zephyr Xavier, or Zephyr Xavier?
Yes, it does.
Your Honor, State would move states 169 to evidence at this time.
We receive as State's Exhibit 169 in evidence. Now, on January 7th, was there a deposit made on the account?
Yes, there was.
How much was the deposit for?
$869.07.
Okay. On January 8th, was there an ATM cash withdrawal at the Sebring Midtown branch?
Yes, there was.
And how much was withdrawn from the ATM?
$300.
And on that same date, January 8th, was there a purchase of $585.28 at Boom Boom LLC in Sebring?
Yes, there was. $585.28.
As part of your investigation, did you go back and determine that the defendant had visited that particular branch on multiple occasions during the month of January of 2019?
Yes.
And on what dates and times did he visit that branch?
January 7th at 12:04 p.m., January 8th at 2:59 p.m., and January 19th, 9:13 a.m.
And were you able to review the video surveillance from the cameras and pull video from those dates?
I was.
Showing defense states 221. I'm showing you states 221. Do you recognize this exhibit?
Yes.
How do you recognize it?
I had a chance to review and authenticate and place my initials on that disc.
And is it a fair and accurate copy of 3 videos from the SunTrust or Sebring Midtown branch depicting visits made by the defendant, Zephyr Xavier, on those dates?
It is.
Your Honor, State would move states 221 into evidence at this time.
No objection.
We received as State's Exhibit 221 in evidence.
first video that I'm going to play through, publish, is the ATM withdrawal on January 8th of 2019. Now, right here, there's a little box off to the side. What type of information is displayed in this little box here?
Show the date, time, the last four of the account, and the amount.
So that particular transaction was at 2:59 p.m. for $300 on January 8th of 2019.
That's correct.
And I'm next showing the video from January 7th.
next is January 19th, 2019.
attend to the witness.
No question.
May the witness be excused?
She may.
Sir, you are excused and free to go about your business. Counsel?
It's
Sure,
after
that'll be fine, Your Honor.
Let's take our lunch break, ladies and gentlemen. We're going to excuse ourselves. You're free to go about your business and get your lunch and then return. It is a little after 12. Let's return and have you back here in the courthouse in the ADA entrance where you originally came in, ready to come upstairs and be here about 10 after 1 o'clock so that you can be brought up here about 1:15, and then we will take care of the rest of the afternoon. Do not discuss the case with anyone. Leave your notes there right on your chair. Thank you very much. You're excused for lunch.
All right, thanks, Jerry.
I wanted to verify she was good with the meeting. She said that she could see it. I heard it.
I believe it would be proper for the court to be the one addressing jurors' concerns, not the state or the court's IT person.
I understand that. I didn't hear or know that that was going on. Thank you. No worries. Thank you very much. We'll be in recess.